Hello to those that are here already. We're going to wait about 30 seconds to give people time to log in and get their audio and video set up. So hang tight and we will start very shortly. Logging in and are here a little bit early or on time actually. We're just going to give everyone a little more time. We had about 100 registrants. So we all know how things go. You get to things 3 to 5 minutes late. We're just going to buy a little bit more time for people to get in and we will start. After we're going to get going, we're going to hop into logistics. More people will sign in as we go and we'll get going here. So my name is Larkin McGowan and I am a corporate marketing manager over here at Armanino, and I support the Risk Assurance and Advisory Group, who you're going to get to meet quite a few of them today. And we are very excited to be here. We're excited that you are here. And I'm just going to go through a couple of logistics that have to do with pushing buttons and things like that, and then we'll kick into the meat of the webinar. So we are in the tool GoToWebinar. We are used to Zoom, I think, nowadays. So just be aware that you are in the GoToWebinar tool, and there is a toolbar that pops up for you. You can minimize and maximize. You can mute yourself. You can also just make sure that if you are calling in through a phone for any reason or on the computer, you're just going to want to make sure that you've got those settings correct in order to assure that you've got good audio. So today there is CPE available, and in order to qualify for that CPE, you are actually required to log in through a personal computer and not a phone. So make sure that you are signed in with your identified information that you registered with. Make sure that you are logged into the software for 50 minutes. So make sure you stay through the webinar. It's going to be compelling and great, so you're going to want to stay all the way to the end. Also, make sure that you participate in the polling questions. So 75% of the polling questions, you're required to participate in order to get your CPE. We have 4 questions for you. Make sure you answer 3 of the 4 at minimum. And then make sure that you complete the evaluation at the end of the webinar. I do believe that once you log out of the webinar, a survey either immediately pops up or it is emailed to you immediately. So make sure you keep your eyes open for the survey. All right, so what you're going to learn today, you are going to learn about global data protection developments that could impact your compliance building blocks, evaluate the status of personal data transfers after the strike down of the EU-US Privacy Shield, evaluate data protection impact assessments, including PORT-IA and AIA, identify privacy complexities stemming from the rise of M&A transactions. Today, you are going to hear from Morena Taskova, Pippa Kem, and Liam Collins, and I'm going to hand it over to Liam to introduce himself and kick us off.
Thank you.
All right, Liam.
Thank you, everybody, for joining. We're very excited for this quarterly privacy regulatory update with you guys. Lots of great content, as Lorcan has said, around updates to CPRA, a global privacy update, and then, as Lorcan said, with the significant uptick in M&A transactions, just considerations around privacy and how that it can impact those transactions as well. I'm Liam Collins. I'm the partner in charge of our risk assurance and advisory practice, the practice that covers our cyber privacy services, Sarbanes-Oxley, SOC, ISO, and HITRUST, pretty much anything to do with risk management. I'll hand it over to Morena.
Thank you, Liam. Pleasure to meet you all. I'm very happy that I have the honor to be part of this webinar today. My name is Morena Taskova. I'm a head of privacy and cybersecurity practice at Armanino. And today we will speak more about privacy, about the latest news in privacy. You will see there are many, and people will continue and speak about M&A transactions. She's going to speak a little bit more about the CCPA, and let's start. All right. So the first thing that I would like to talk about are privacy developments in Europe. And let's start with that. So first of all, there are many, many data privacy laws around the globe. Most of them are following the GDPR standard, I would say. And therefore, I will speak about that's why I will start with Europe. And you will see that Europe has a lot of news in privacy. All right. So according to the European Data Protection Board, he recently published a few guidelines that I would like to mention. And you will see that the final version of the guidelines on Article 25, data protection by design and by default, has been published. Also, the European Data Protection Board published the guidelines on the concepts of the controller and the processor. It's a version for public consultation, and also guidelines on the concepts on the targeting of social media users, again, version for public consultation. There are also some news from the French Data Protection Authority. One of these news is that as a result of the Schrems II decision, for which people will discuss later about the invalidation of the Privacy Shield, we also had some media reports that CNIL recommended France to end data transfer to the United States in the context of the Health Data Hub. Health Data Hub is an information system that is designed to gather all health data of the entire population receiving care in France. So far, this is not a prohibition for transfer. This is a recommendation. And also, they look into changes with Microsoft and how they are going to strengthen the privacy protections of that data. Another announcement that CNIL recently made is that it has adopted amended guidelines and final recommendations on cookies. Then we should go to South America, which also have news in privacy. Brazil recently adopted a personal data protection law, but what's more important, that now it has a data protection authority, which means that the enforcement can begin. There are 5 new directors that have been nominated, and we are expecting publication in their official state gazette next week. You will see the names. Some of them are Valdemar Jr., who will be the chairman. There is also Miriam Wimmer, Arthur Pereira, and they have different mandates, as you will see. Another thing that is happening in the world is in New Zealand. A new privacy law is coming into effect in New Zealand on December 1st, 2020. Some important changes include mandatory reporting of privacy breaches, enhancing the role of the Privacy Commissioner, strengthening the protections for information disclosed overseas. Further, we go to China. China has the first comprehensive privacy law coming. There is a draft of personal data protection law that has been released for the public consultation earlier this month. And again, similar to many other countries, the GDPR has been used as an inspiration. And last but not least, indeed, is what's happening in the United States. United States has several developments in privacy, one of which is Section 230, as the CEOs of Twitter, Facebook, and Google yesterday testified before the Senate Commerce Committee to defend their legal liability shield. Section 230, just for information, protects tech platforms from liability from their users' posts and allows them to remove posts. And something that is coming very soon, in a few days, is Proposition 24, which is the November ballot initiative, and whether we will have California Privacy Rights Act. So far, the polling results show that 77% of the voters says that they will vote yes on that ballot. But of course, there is much more to say about that, and we should start with the CCPA, thinking how CPRA even came up. And people, please feel free to continue and jump in this call.
Yes, thank you very much, Lorena. This past year has been very active for the CCPA and for companies that have to comply with the regulation. So first thing first, take note, both the statute and the CCPA regulations are both in effect. As a result of being in effect, the California Attorney General has also started enforcement actions. So a few things to note about the CCPA. There are some provisions that have been or deleted. Those provisions are listed on the slide, so I will go briefly over them. The first provision to get deleted is the requirement that businesses that have interactions offline with California consumers need to also provide an offline mechanism for opt-out. Obviously, one can imagine the difficulties or challenges faced by organizations trying to onboard an online mechanism on your website to opt out, and then having to then deal with providing a process for offline opt-outs. Another section that was deleted is the section requiring consent, explicit consent, in order to repurpose information that companies have, that businesses have already collected. No need to obtain explicit consent in order to reuse information in a different form. Also, the CCPA, another section that has been deleted from the statute is the section that abbreviates "do not sell my information" link. In order to be consistent with other sections of the law, the abbreviated description is no longer. And then lastly, the requirement that businesses also have changes in their privacy policy to effect an opt-out provision. There are some adaptations there. So bottom line, really, businesses that have complied, put in place compliance systems, compliant processes, need to go back and see what has changed, and then to make the necessary adjustments to their CCPA processes. I earlier mentioned that there is enforcement action that began back in July, on July 1. And what we're seeing in terms of enforcement action is that the AG is focusing on those violations that companies sometimes overlook. Do not sell my personal information. If you are a company that needs to have that link on your website, you need to make sure that you do provide that mechanism for consumers to opt out. Also, the Attorney General is monitoring complaints and lawsuits that have been filed. I will move on to the next slide just to show the lawsuits. But very briefly, there are two bills that passed, 1281 and AB 713. 1281 extends the exemption granted to employee data and B2B from CCPA applications, of course, with the exception that the data breach, private right of action still applies. And 713, AB 713, then clarifies that HIPAA regulation still controls everything related to health data. Sorry, I need to move back a slide. Oh, can we move back 2 slides now? It's okay. Technical issues there. So some key points that I wanted to note in reference to the CCPA are, the litigations that have been filed so far. Up until October 19th, the IAPP is reporting 22 cases filed. And out of those 22 cases, I mean, you have a multitude of claims. You have lack of notice to out-of-date notice to notice not being provided at all. 10 claims all deal with notice, and it's quite interesting to see the basis of those claims. And another point I wanted to raise was the issue of CCPA penalties. CCPA penalties apply to all organizations. By that, we're looking at for-profit organizations that are in scope of CCPA. We're looking at businesses, we're looking at service providers, we're looking at third parties as well. And in terms of violations, we're looking at failing to maintain a CCPA compliant privacy notice on your website, failing to respond to consumers' requests for their information, failing to provide an adequate notice at the point of collection, or selling personal information without the appropriate opt-out mechanisms. Keep in mind that penalties can multiply depending on the number of violations. So, for instance, if you have an out-of-date notice, and that is a violation. If you have an individual, a consumer, visiting your website over and over again, that counts as a single violation against that consumer. But it does not count as it multiplies if you have several other individuals visiting your website. So something to keep in mind on that. Now, onto the new ballot. There is a new initiative that needs to be on everybody's radar, and that's the CPRA, the California Privacy Act. Privacy Rights Act, also known as CCPA 2.0. That's the more common acronym used to describe that. It will overhaul the CCPA, and this is a November 3rd initiative, so it is on the ballot. And it's expected to pass, as Mirena earlier mentioned. Highlights of this new regulation. It will create a brand new agency called California Privacy Protection Agency. Under the current law, the AG is responsible for all enforcement action. Well, this will now shift to a new agency. And the same penalties, civil penalties apply for negligent violations, $2,500 max for negligent violations, and $7,500 for intentional violations. It's expected that fines will partially on this agency's activity. And one thing to note about this this new law, CIPRA, when it does pass, it extends the regulatory reach far more than the topics, the regulatory scope far more than the topics that are currently covered by the CCPA. So think of it as HIPAA. It really moves the CCPA closer to HIPAA. All you have to do is to take a look at the new rights that will be supported by this new law. There will be sensitive personal information and a right to restrict use of sensitive information. Just as with the GDPR right of rectification, you will have a right to correct any inaccuracies. You also will have a right to stop companies from storing information longer than the business actually needs it. And that's very similar to the storage limitation under the GDPR. And I'm sure everybody is familiar with the concept of data minimization. That is also part of this regulation. And so is restricting advertisers' access to your geolocation, precise geolocation data. I'm sure it sounds very familiar to all that's happened with GDPR.
Can I chime in? I'm so sorry, Pippa.
Yes.
We are having some audio issues. We can hear you, but we are struggling a little bit. So this is my job on the logistics side. So hang tight, everybody. One, I'm going to ask Marina, can you make sure you're muted? And then Pippa, just so that the rest of the time is smooth, I would just see if you can be a little more direct into the mic, or see if you can, sometimes microphones are quirky, so it's doing something. And so just maybe project a half a hair more and be more direct on the mic. And then Marina and I will make sure that we are muted so that we're not causing any feedback. Sorry, Pippa, and thank you.
So are you hearing me now? Is it? Yes. Okay.
Yes.
So moving on then to the last piece of update on information on what's happening in the US landscape. You have the federal privacy legislation. It's still a legislation in the making. The latest update on that is that congressional members, there is a committee that has met with state and federal regulators to discuss what this new law would look like, and especially focusing on current state laws and trying to avoid duplication of privacy requirements. So, two focus of the new regulation would be to ensure that there is a balancing of rights to protect consumers, to protect the personal information of consumers, while not having duplicative processes. With that said, Lorena?
Hello. Well, I'm happy to continue with just a few words as soon as I'm able to change the slide of this presentation. And here, the only thing I'm going to say, and then I'm going to let people continue, is that we will continue with a few brief concepts before starting with the M&A transactions. We will speak a little bit more about the US data transfers, about the invalidation of the privacy shield. We will touch upon some very interesting new type of assessments, which is algorithmic impact assessments, portability and other required transfers impact assessments. Whether they are like the data protection impact assessments under Article 35 of the GDPR is something that you will learn later. Thank you. Pippa, please feel free to continue with the EU privacy shield.
Thank you. Having some technical challenges moving the slide. It's not moving. Well, to continue with the US privacy shield, a lot has gone on. Obviously, the biggest news is that the privacy shield is no more. That was the principal mechanism for the transfer of data from the EU to the United States. The validation of the privacy shield came as a result of SHRM's 2 case. Essentially, you had a challenge by an Austrian data privacy advocate who essentially was challenging the legality of personal data transfers to Facebook Inc., located in the United States. So there we are. The result of that ruling is essentially that a privacy shield, companies can no longer rely on the privacy shield to lawfully transfer information to the United States. And the courts were basing their decision on the fact that you do have very extensive surveillance activity taking place in the United States. And as a result of those activities and the fact that there aren't what the court considers adequate protection of personal data, similar to those that are operating or established within the EU by the GDPR, the Privacy Shield is no longer. But it's not all bad news. You can still transfer data using any of the other mechanisms that are authorized by the GDPR. One of them, of course, is the standard contractual clauses. Those are pretty much pre-approved clauses that can flow into your existing DPA, data protection agreements. If you are part of a corporate family, you can also rely on binding corporate rules, BCRs, to enable transfer. Again, it can be costly trying to get on board with the binding corporate rules, but something to keep in mind about the options that are out there. Speaking of the effect that the Shrimps case has had, you do also know that there is a Swiss US Privacy Shield that was invalidated as a result of the inadequacy ruling under Shrimps. Oh. Okay. So before we go to the polling questions, please.
Okay, everybody, we have a polling question for you. You do need to participate in the polling question. So here we go. So do you have appropriate privacy processes and or systems that you can leverage for CPRA compliance? Yes, no, or not sure? So go ahead and take a few moments, answer the question that should pop up on your screen in a nice little box where it gives you an opportunity to select. Okay, so go ahead. We will close the poll in just a moment. 3, 2, 1. Thank you. All right, so very intriguing. 35% yes, 10% no, but we've got quite a bit, over half that are saying they're not sure. So the good news there is you have Morena and Pippa to help you out. So after this webinar, we will reach out to you and certainly make ourselves available. All right, second polling question. Does your organization participate in the US Privacy Shield program? Very interesting question here. So does your organization participate in the US Privacy Shield program? Yes, no, or not sure? All right, make sure you vote if you want your CPE, right? So make sure you participate. Let's go ahead and close the poll in 3, 2, 1. All right. We beat the 55% and got to 60% on the not sure. Very interesting. So again, we know a lot is changing in the privacy landscape, and keeping up with regulations and laws and how it applies to your organization, we understand is hard. So that is why we have our experts, Morena and Pippa. So please be sure to reach out to us if you need us, and we'll reach out to you. Let's go ahead and move on with the presentation. I am going to just express one more time that the audio is a little rough. I do, just Morena and we will make sure that we're muting ourselves to help with any feedback. And then Pippa, probably a little bit, see if you can project a little bit more just to help the audience be able to hear you a little bit more clearly. All right, guys.
All right, so I will make sure that I'm not muted for this part, Larkin. All right, so I would be very happy, and as I said, first of all, I'm very surprised of some of the polling questions, especially for the Privacy Shield. Just so you know, something that I would like to mention before to proceed with the data protection impact assessments and with the other assessments is Privacy Shield is a mechanism for transfers from Europe to the United States. And when you look into such transfers, think about, did you sign any contracts with standard contractual clauses embedded in them? or whether you have any type of registrations for Privacy Shield. They are alternative mechanisms. They don't need to go together. So if you have standard contractual clauses, you do not need Privacy Shield. And now I will continue here with the data protection impact assessment, just as a brief reminder of a data protection impact assessment, so I can continue with the new assessments, which I find to be very exciting, is the data protection impact assessments under the GDPR is strongly embedded in the GDPR as a basic mechanism to assess whether, first of all, to build and demonstrate compliance, and also aims to describe the processing, aim to assess the necessity and proportionality of this processing, and to manage risks to the rights and freedoms of the individuals. Often, if certain activity or and let's say service could present high risk to the individual's, data protection impact assessment has to be done. But very often, as a best practice, companies are implementing and executing data protection impact assessments for their new products and services. And here, where we will continue with the algorithmic impact assessment. Algorithmic impact assessment is not necessarily fully envisaged by the GDPR. The GDPR specifically mentions execution of data protection impact assessment in case of automated processing. And they are similar. The algorithmic impact assessment is similar to the data protection impact assessment, but also differ in some ways. For example, it could often be performed either together or before data protection impact assessments, very much focused on artificial intelligence. And the advantage of such separate algorithmic impact assessment is that it can provide detailed review of specific AI risks that are not necessarily only privacy risks. We talk about bias, we talk about ethical considerations, use of confidential information, use of algorithms where the results cannot be explained. Very interesting impact assessment if you want to use artificial intelligence, which many companies now are looking to do. Another thing that I want to mention, this is in relation to a very recent workshop done by the FTC in relation to data portability, which is a very interesting topic. I highly recommend focusing on the data portability right. And data portability require various complex matters to be reviewed. And this is where the portability and other required transfers impact assessment have been presented at the workshop of FTC. So the data portability and other required transfers impact assessment so far is kind of more on the research side, but I see that people are starting looking into it. Again, it is similar to the privacy impact assessment, but also differ in some ways. Again, it doesn't involve necessarily only privacy. First of all, it aims to assess issues of data portability and other required transfers of data. It definitely provides a review from privacy perspective and cybersecurity perspective even, similar to the data protection impact assessment, but also focuses on other essential elements like competition. And as a similar example of what is involved of such assessment, again, it can provide description of the data flows, similar to the data protection impact assessment that also describes the processing of personal data. It assesses data portability benefits and assesses data portability costs and risks. It looks at it from privacy perspective, cybersecurity perspective, but also it looks at it from competition perspective. For example, what are the competition complexities, whether we have lock-in effect, whether we have network effects. It looks at it from non-commercial perspective. It looks at it from regulatory and legal benefits and innovation perspective. Same in terms of costs and risks. What are the competition risks and what are the competition incentives? And here, again, I will give the opportunity to Larkin to ask some polling questions, and let's see what the results would be. Thank you.
Absolutely. All right, so here we go. Polling question number 3. It should be popping up on your screen shortly. All right. Do you have difficulties in assessing the risk for your organization while performing data protection impact assessments? Yes, no, not sure. So assessing risk, how is it going for you? All right, we'll close the poll in 3, 2, 1. Yes, and not sure. No, ooh, I like the no's. That'd be a good, you don't have difficulty with it. I find risk assessments quite complex. All right, so yes and not sure. Let's keep talking about it.
Very interesting results for the data protection impact assessment. It's a very good topic. We will make sure that we focus on that topic also in the future. Stay tuned. People, please feel free to continue with the privacy complexities in M&A transactions, which is another very interesting topic, especially now in times of the pandemic.
Absolutely. Just wanted to comment that the numbers on the DPIAs are pretty average. That's what we're seeing when it comes to using that tool. So moving on to M&As, mergers and acquisitions. The pandemic is quelling a lot of transactions. If you are a buyer, you need to be concerned about the potential compliance obligations that you may have as a result of your acquisition. And if you are the seller, you need to be on your toes, you need to be on your feet, and be ready, be prepared to answer some of the top questions that may come from the buyer with regards to your CCPA compliance efforts. So essentially, looking at the issue from a regulatory legal standpoint, you do have laws that are out there, you do have global privacy regulations, you do have laws that are within a jurisdiction, just as you have with the CCPA, that have requirements around privacy that want to ensure that companies processing personal data have the appropriate privacy and security controls in place to protect the information that they have. So it's an area that you need to look into for a target company. You need to know what their CCPA obligations are if they have any interaction with California consumers. When it comes to reputation, a big example of what not to do is the Verizon Yahoo deal. Essentially, Verizon finding out after the fact that there was a data breach, and of course that has some consequence. But it's something to look into. If you're a purchaser, you need to ensure that you ask the appropriate questions around data breaches, around practices, privacy practices, around systems that are in place. So you at least know how to manage any eventual issues that could impact the reputation of your company. Looking at internal processes, we are looking at what makes up your privacy program, what makes up your privacy controls, and those are policies. In any M&A transaction, you will need to scrutinize the privacy policies that are in place, the security policies that are in place, the practices that are in place. All of these things need to align, right, between the purchaser, the target or selling organization, and everybody else that is in the mix if you have subsidiaries. And then lastly, domestic and international laws. As you saw earlier, they are mushrooming. I mean, there is no jurisdiction, there is no place around the globe that there isn't some element or effort towards establishing data protection measures. And then thinking of the pitfalls or consequences of not following the rule, not making, not following up with the right inquiries, doing your due diligence. Some of these, I mean, there are many, but just a few that have impacted global companies that have made the news, usually revolving around trans data flows, not being able to transfer information to where you may need that information to function as a business. And then you have the potential scrutiny from federal, state law enforcement actions. You don't want that. Those are typically very costly and time consuming. So we want to minimize that. And you could also face litigation if you've not done your due diligence as a purchaser. You could face litigation from consumers, privacy advocates, business partners, who somehow find out that your privacy practices or the target company's practices have been compromised. Loss of income is also another area. No company wants to lose their lifeline when it comes to income. And lastly, very intrusive government investigations that may result in having a big brother type of compliance program. We don't want that. So what are some of the best ways to avoid the pitfalls? Well, as I earlier alluded, look to the risk and potential liabilities that may come from your due diligence as a result of the due diligence work you've conducted on the target company. You may find that they have inadequate privacy policies or practices, or ineffectively designed security controls. It takes a little bit of digging, right, in order to find out some of this information. Do your due diligence. A starting point, I think, I would say, for an organization, irrespective of size or revenue, is go to the website, look at the privacy policy, see what commitments are represented in the privacy policy. Ask for policies, for instance, classification, retention policies that relate to the public representations that appear in the privacy notice. And sorry, the slide just always disappears. And that was a wonderfully crafted slide. Can we go back to the previous slide, if possible? It's not allowing me to. Oh. The previous slide. There we are. I didn't want anyone to miss this. So let's take an example with the CCPA. As I earlier mentioned, the State Attorney General has begun enforcement action. And I always like to go to companies' websites to see what they are representing in their privacy policies. And I am seeing a lot of policies that have not been updated with CCPA requirements. So a starting point might be to get the privacy policy, go through it, and see what processes have been established. If there is a DSA process, something as simple as a data subject access request process, if they provide a mechanism for requesting, for a consumer to request their information, test that process throughout the organization. Ask for policies, ask for workflows, procedures, any documentation you have across teams within the organization to have an understanding of how that process actually applies, how has it been implemented. And if you see gaps, it's a good thing to note and to observe and follow up on as part of the due diligence action that you undertake. And then organizationally, CCPA, like most other privacy regulations, it's all about having an account. So you need to look through the organization, through the teams, through the structure of the organization to find out who is responsible or accountable for day-to-day privacy management concerns. That would give you a pretty good sense of how valuable, not maybe I should take that back, but practices around data handling. And then the technology. You tend to see a lot of solutions out there automating the process around DISA, automating the process around inventory. So just try to see if there are centralized tools to manage processes that are described in the privacy policy online. That should give you a sense of, what do I need to do to understand the level of CCPA compliance that has been enforced at the target company. And then compliance really deals with reporting, with monitoring, with following up on complaints, privacy-related complaints. A good way to really gauge how a target company practices have been implemented is to look at their complaint reporting process. Have they investigated any privacy complaints? How do they handle inquiries? Is it timely? Is it resolved? And just follow up, follow through. So it's not an easy undertaking. It's very daunting, but a necessary task to fulfill in order to scope your CCPA liability. So with that said, Lorena?
Lorena, we don't have your audio.
And here you are. I'm muted following instructions. Here I am again. I just wanted to say that there is a lot for me to say about the M&A transaction, but what I would like to speak about today is the GDPR perspective, not only the CCPA perspective. As we already seen in the beginning of this webinar, GDPR is our standard, so we also have to consider what's going on there. When there are M&A transactions, I strongly recommend thorough review of the target company. There are various reasons why such thorough review is needed. One reason is from privacy perspective, another is cybersecurity perspective. Very often there could be breaches that are found post the transaction, and you need to know what you're gonna do if you find out that your target company had a data breach before you purchase that company. Another thing that I would like to mention here is process that we need to follow when we evaluate that target company. A few things I would recommend here. They are not, of course, this is not an exhaustive list. There are many things that have to be taken into consideration, but I would find this very helpful if we start from somewhere and then we continue with the deep dive. The first thing that I would like to mention here is we have to assess the personal data flows of the target entity. What type of personal data they process? Why do they process that personal data? Who has access to that personal data? Whether they transfer personal data. We already seen earlier that there are issues with the data transfers from Europe to the United States at the moment. They have to be considered. Another thing we need to take into consideration is the applicable basis for personal data processing. Do they process personal information on the basis of consent? Do they process personal data on the basis of legitimate interest? Do they process personal data on the basis of contract? Another thing that matters a lot is the internal privacy and security practices and procedures of the target company. What has been envisaged there? What do the employees know about the processing practices of this target company. Employment data matters in M&A transactions, since most likely in case of an M&A transaction, there would be exchange of employee lists between the companies. Another thing that we need to take into consideration is if there are any previous privacy and cybersecurity audits or assessments of the target company. Ideally, 5 years back in time would be a good potential option for a proper review, and they can say a lot about the posture of the company. Another thing that we need to focus on are the privacy records. The records matter. The records basically prove this is something that it's an obligations under the GDPR Article 30, and it also kind of give additional information similar to the personal data flows of what's happening with the data, who is responsible for the data processing practices for certain processing activity, let's say marketing, and how they handle that data. As we mentioned earlier today, data protection impact assessments of the target company matter as well. They matter if they have certain sensitive type of product or service. It matters to assess the risks. As I said, it is not easy to assess risks. It's a very abstract matter. We, for example, in our company are looking into a new potential opportunity to put numbers on these risks. So actually we can properly assess the risk, which is through FAIR. So stay tuned about that. You will learn much more about that later, or feel free to reach out to learn more about that. And then something else we need to mention, our relationship with third parties. What's happening with their vendors? Who support them with their activity? Do they have soup processors? What's gonna happen post-transaction? And last but not least, a few things that I wanna mention is something that already people discussed: exercise of data subject rights. What are the internal practices? What are the internal practices for marketing? What are the internal practices for analytics? If you're using artificial intelligence, which is something new, what is the coordination with the team about such use? Whether you're using big data, how are you using that data? This matters a lot for a target company. And also verify if they have data protection registration, if they have global operations, if they have access to different countries. Some countries require data protection registrations. You might need to change that registration upon acquisition. And again, and this is where I will finalize my very brief input today, but data breaches, cybersecurity incidents, it matters a lot how you handle that matter. It has a lot of negative consequences, financial, reputational, you know, the brand name of the company is on the stake. So make sure that you properly verify or do cybersecurity assessments of the target company. And you know, this can also lead to complaints, investigations. They are all connected. And this is where I would like to thank you very much. I will leave the team to also finalize this presentation, but feel free to reach out, to ask questions. We'll be always happy to respond. And if there is any topic that you would be very much interested to hear about, we are here for you, happy to accommodate and talk about it. Thank you.
All right, everybody. I believe Pippa, did you have one more thing you wanted to cover that we missed?
Yes, absolutely. Slide 22, we can jump to that slide. What comes next after the demise of the Privacy Shield? Fielding a lot of questions from clients on what should happen to their privacy policies. Well, the simple recommendation is do not delete the references to the Privacy Shield, because if you continue to participate in that program, you are still obligated to see into the safeguards that the program provides for the information, the personal data that you've collected, that you continue to store, that you continue to maintain, and most likely still use. So you still need to recertify. I would encourage everyone on this call to get very acquainted with the statements that have been issued by the U.S. Department of Commerce and also the EDPB, the European Data Protection Board. There are very insightful statements that will enable you to consult with legal counsel to determine what next. Don't forget to incorporate the standard contractual clauses into your DPA agreements. And it's a wait and see game. History repeats itself. So I'm sure we'll have a resolution to the privacy shield. Thank you.
Great, thank you, Pippa. Okay, everybody, we've got our last polling question. So here we go. So how do you track or monitor new privacy compliance requirements and best practices? You assign them to a team or individual, you rely on reporting services or law firm update, social media, industry events, or you do nothing. So how do you track and monitor the new privacy compliance requirements? We know a lot has been unfolding this year. So this is a true subject that many of you have to address almost daily. All right, so we'll close the poll in 3, 2, and 1. All right, so assigned to a team or individual or rely on reporting services and law firms are our top 2. Some of us are doing nothing. Some of us are kind of watching industry events. I'm very proud of everyone that social media is a 0 because I don't think that's the right place to get it from. All right, so we are at time and we are very glad that you spent this time with us. Thank you so much, Pippa and Morena, for really giving us a tremendous amount of information, and it's very clear your expertise in these subjects and they are quite in depth. So I just want to thank everyone again. Thank you, Pippa. Thank you, Morena. Thank you, Liam, who you saw earlier on the call. And thank you everybody for attending. We hope you have a wonderful day. Don't forget to take your survey in order to qualify for CPE. All right, everybody, take care. Bye-bye.
Thank you.